Generally not joint tenancy if they're doing it as business partners.
Okay.
I would actually never recommend joint tenancy when doing it as business partners, because unless the intention is to create a right of survivorship and that you are supposed to benefit in my 30% if I pass away, which I like you, but I don't like you that much.
So if you're investing with a business partner or partners, then probably tenancy in common is the best way to go about that. Hello, everyone. Welcome to Bamboo, Vancouver's property management and investment podcast. We're here today with Mike LeBeau of LeBeau Law, the guy with the name on his wall. So what we're going to talk about today is a couple of items just to deal with the legal part, to do with purchasing a property, investment, or otherwise. So without further ado, welcome, Mike.
Thanks, Haze. Happy to be here.
Mike, and glad that you are here. We did have a couple of questions that came in from some of our people in a landlord group that we're with. So we'll cover some of those as well.
Sure. Sounds good.
So I guess really, how long have you been at this, by the way? Like you've been a lawyer for some
16 years. Yeah. 16 years. I started in 2008. I was called to the bar in 2008 and decided to start my own practice because I didn't really want to commute downtown anymore. And so I decided to start a practice where I commuted all over the place to see people instead. So, yeah.
We actually have a question about the commuting part in the digital age now. So it's kind of it's a good segue. Thanks, Mike.
It's an interesting element that's evolving currently.
Yeah. So why did you get involved, though, in real estate law? Because, most people think lawyers and they see the U.S. station and, fight the man type of thing. This seems kind of, boring, not as sexy.
So the real answer is that it was kind of by accident.
Yeah.
I had done a lot of my pre-practice work in immigration specifically.
Okay.
Prior to going to law school, I worked for a criminal and immigration lawyer. And I knew I didn't want to practice criminal law because,
it's kind of depressing.
it's quite depressing. And I wasn't interested in having that interaction with the clients and whatnot. Everybody does deserve a chance at justice. It just wasn't one that I wanted to be an element I wanted to be a part of. But I did get heavily involved in immigration.
Yeah.
And did quite a bit of work with him on some really interesting things. And my articling year, which is our sort of like practicum year before we start practicing, was an immigration firm, but they were downtown and I didn't want to commute. And so I decided to start my own practice. And my original goal was to focus on immigration, and I was going to become a negotiator and start working on negotiations and mediations and that sort of thing. But I decided to get involved in real estate just because I had somebody close to me that was involved and knew a couple of realtors and whatnot. And many that and the interesting part was that 2008 was a time where the market was evolving.
Very PC.
It was sort of the start of a bit of a downturn right when I started my practice.
Yeah.
And I didn't really even know that at the time. So as I started practicing, it just gained a lot of traction, and I liked the work because I think it's interesting. You're helping people doing something that they want to be doing.
Yeah.
It's mostly a positive experience for people. There are certain exclusions apply.
Of course.
And it's something jokingly around the office we refer to it as happy law. You're not really taking anything from anybody. You're helping people achieve their goals. And so that's sort of the positive side of it. And I enjoyed my client interactions, and my practice developed quite quickly in that area. So it kind of took over what I was doing. Cool. So while we do still have a very active immigration practice, I'm not as heavily involved in it anymore. I mainly focus on real estate and development.
Yeah.
So.
Yeah. Generally with the sales side, I've noticed between the sales and the rental side, the sales side is usually pretty stoked. People are happy to get what they're getting, they're moving on, they're making the big step type of thing. I can get what you're saying with the happy side of it.
The only real unhappy part is when you have people who are going through foreclosures or people who are splitting up and aren't happy with how things are happening for the most part. Other than that, pretty much everybody wants to be doing what they're doing.
Cool, which is actually a pretty good segue. One of our questions was, can you explain common legal issues that buyers and sellers face during a real estate transaction?
So there are a few things that arise semi-regularly. Ideally, the contracts are drafted well enough that we don't really have any issues.
Because we're awesome.
That's but yeah, you'd be
Maybe
surprised. There are things that arise on occasion. The biggest problems post closing, of course, are related to disclosure of defects, which I know we may talk about a little bit more as well.
Yeah.
There are some items that again occur post closing because a lot of things happen after possession. So disclosure of defects, included items. People show up and go, "Where's the TV mount that was supposed to be here?"
Yeah, the difference between a chattel and a fixture is a big thing. Now, actually, it's a good question. By the definition of the law, what is the best way? I mean, we generally say anything that's bolted to the wall, but I mean, you can bolt a bookshelf to the wall so it doesn't tip over, but that doesn't mean that it's now part of the home, right? Or does it?
It can be a gray area, and for the most part, common sense applies.
Yeah.
And that would be a good example where you have a large freestanding structure that has a little fabric ribbon from IKEA attached with a single screw. I think most people would be hard pressed to try to argue that it's a fixture.
Yeah.
You will probably get some people that do because just of differences of interpretation and whatnot. Ideally, though, it won't be a big fight because most people will let common sense apply.
So I mean, I guess it's best to almost like overwrite the contract, like list it, right? Like there's no harm in writing down, this is staying, this is going, right?
The single biggest factor to avoid any complications in property transactions is clarity of contract terms. So while disclosure of defects included items can be big issues, another big one is GST, whether it's included or not, or whether it applies or not, that sort of thing, particularly in assignments. But those things are things that can very easily be resolved through the initial contract negotiation phase.
Yeah, just write it down, right?
You'll probably have found over the years, and what I see a lot of is everybody knows what we meant.
Yeah. No, they don't.
If you meant it, then put it down.
Yeah.
Right? Write it down. Make it clear. Leave no opportunity to have a dispute over it.
Yeah. Yeah.
In my years working in immigration, there's a lot of advocacy involved in that. And we always sort of said, make it as easy as possible for the decision maker to say yes.
Okay.
And so you can translate that to contract drafting to make sure that if you're intending for something to happen, make it very clear that that's what you're intending to happen. No sort of, we'll leave that a little bit open.
Yeah. It's like straight up.
Yeah. Now, that being said, that can damage negotiations. When a buyer is trying to convince a seller to do something and hope that they're on board with it, if they're too firm in their wording, a seller may push back and reject the contractual terms.
Yeah.
And that buyer may then potentially lose the opportunity. So people have to pick and choose, but also they have to be aware that by picking and choosing, they may be creating future challenges.
Yeah, absolutely. Well, you were just talking before we got on the air here that you're talking about clarity in one that you're dealing with.
Yeah.
Like, is that sort of along the lines that you're talking about?
Yeah. So I'm dealing on an investment property right now, so very pertinent to what we're dealing with, where a client is buying a unit in a hotel property where the individual rooms are strata-lots, basically. And the hotel manages a bunch of the finances, and there was a clause where some of the financial elements in my client, who's the buyer, in their mind, something was meant to be excluded from reimbursement to the seller. And in the seller's mind, the intention was for it to be included in their reimbursement to them because of like the financial part managed by the hotel. And there is just enough ambiguity in the way that things are worded that both people could be considered right, depending on how you look at the whole
as a whole
history of contract drafting and intentions and whatnot. And in some ways it's actually very, very clear, but in other ways, while it's clear, it also does leave room for well, but then there's that.
Yeah.
And so it will probably get resolved the best way to resolve these, which is where nobody's happy and they just split the cost. And so it's a $16,000 issue that they'll probably go $8,000 each way. I'm getting pop-ups while we're talking, saying that that's probably what's going to happen. And that will be a position where my buyer's not thrilled to have to pay $8,000 more than they were intending.
Yeah.
Although they're the ones that are going to benefit from that $16,000. So for them to only have to compensate for half of it instead of all of it.
Yeah, fair enough, right?
Whereas the seller was intending to collect $16,000 and is only going to collect $8,000, so they're unhappy. But at the same time, nobody's going to go to court and spend $100,000 fighting over $16,000.
Yeah, which would be kind of silly, right?
Exactly.
So I guess in a nutshell, the term to learn is don't be ambiguous, just be specific.
Yes, and one could argue in the original review of the contract that it seemed quite clear.
Yeah,
but it's not till somebody goes, well, wait, that's not what we think. Sometimes it's really easy to spot an ambiguity up front, and sometimes you don't see it until after. And one of the challenges with this is that a lot of these contracts don't flow through us as lawyers at all. Yeah. We don't see them until after they're already done. Subjects are off, everything's proceeding. And all that, and so we haven't had a chance to give any input. Not that we're perfect and that every contract will be perfect as a result, but it's another set of eyes, and a particularly set of trained eyes, right? That can enhance the potential wording, or potentially, that was my watch on that can enhance and potentially prevent ambiguity. It's another set of eyes in contract drafting. So it doesn't hurt, but nobody wants to pay us $1,000, $500 to review and rewrite a contract that may or may not get accepted, right? Yep. So
that makes sense, right?
It's that same thing about negotiating with the seller. You have to pick the battles that you want to fight up front and hope that it works out for the best in the long run. However, if this had been addressed at the beginning, we probably wouldn't have this issue, because I know when I looked at it, I was like, okay, oh no. So, and that was before it even became a fight.
Yeah, which one of the other questions we have are what are some of the key clauses in real estate contracts that people often overlook and should maybe pay a little bit more attention to? Like, what do you see? Because you get numerous sales from all sorts of realtors and do-it-yourselfers and everything, right?
Absolutely, yeah. Probably the single biggest source of confusion, particularly in relation to investment properties or commercial-ish properties, that sort of thing, or new, semi-new properties, is GST. Okay. Now, I'm not an accountant, but I don't feel like you have to be.
Yeah, fair enough, right? They're pretty straightforward on the rules.
Well, yes and no, though, because there are some that you do have some ambiguity in as to whether or not it will apply in certain situations. Now, CRA has kind of made some changes over the years to make it more likely to apply than not. Yeah. But a lot of things occur in assignments, for example. I'm not sure if you've done many sort of assignments of new construction.
We've done a few, but now with the new assignment laws, I'm sure we're going to be doing a lot less.
Yeah, we are seeing fewer of them. Yeah. Although, well, I mean, the new assignment laws, they're not really different. All it's really done is sort of codified what was expected before. Yeah. And really all that means is that there is a lot less dispute over things like GST. Yeah. Because now basically GST applies on the assignment amount. Yeah. That's the number one thing. Now, that being said, the default, the standard form contract for an assignment, I think it's clause 5.18, if I remember correctly, specifies that GST is applicable. If GST is applicable on the assignment amount, it's included in the assignment amount. Yeah. So that's saying that the assignment amount, let's just say it's a lift of $105,000. It means it's $100,000 lift, $5,000 GST. Yeah. That's the number that is intended by the wording of that contract, because GST now is applicable basically on virtually all assignments.
Oh, of course. They always want their money.
Yeah. But we just had one last week, 2 weeks ago, where a client of ours was being audited, and CRA was saying that GST should not have been included and was owing on, let's just say it was $100,000. So our client received $100,000,
Yeah.
and that was meant to include GST in the number. And CRA was saying, well, no, you're supposed to pay us 100. You're supposed to pay us 5,000 on top of the 100.
Yeah.
So not only is it not 95 and change, it's actually 100 plus 5. So you're effectively short, like close to 10 grand.
Yeah. Yeah.
And the accountant was like, well, that's what the assignment rules say. And I said, yeah, but the assignment contract specifies very clearly that GST is included in it. And there was an additional term section that specified that the GST was included in the assignment amount. And I said, as much CRA can charge money on the assignment amount, that assignment amount is defined in the contract as being the total minus GST.
Yeah, I get you.
And CRA eventually did come back to them and say that they were accepting that. And I was like, well, it's not even really for them to accept. It's very clear.
Right. You're right.
The only thing that would have made it more clear, and again, this comes down to that clarity of terms thing, specify. Don't say that the assignment amount is $105,000 and includes GST. Say the assignment amount is $100,000 plus 5% GST, so the total is $105,000.
Yeah, very clear, right?
Why leave it to any interpretation?
Yeah, fair enough. So do pay attention to the GST is one of the things that people really overlook, I guess.
It's probably the biggest one. A couple other ones that are pretty common are things like included items or review of strat documents, those sort of things where the investigations made by a purchaser prior to completion, do them, right? Yeah. Do them. Get your property inspected. Read the strata documents, because those are your disclosures. Those are the things that if you choose not to do them, you're basically writing off your ability to have a future dispute with the seller over things that could have been discovered by doing those. Exactly. Yeah. A lot of people say, well, the seller didn't tell me about it. Well, they don't have to. They don't, like, as you know, purchasing property is nerdy Latin term, caveat emptor, meaning buyer beware. Yeah. Meaning it's up to the buyer to make the investigations into the status of the property and what condition it's in. It's not brand new. It's not a warranty. There's no obligation on the seller to say, oh, and by the way, sometimes there's a mouse in the closet in the other room. That's up to the buyer to get an inspector in to say, oh, there's mouse poop in this room. Yeah. You should probably check on other issues that might result from that.
Yeah, for sure, right?
So the biggest thing that people overlook are those kinds of terms. And then the other things that are pretty common are things surrounding timelines, possession, and whatnot. Because I think we've talked before about same-day closings, which are problematic for a variety of reasons that we can dig into if you want to. But even possession timelines, they're supposed to get possession the following day at noon, and they book their movers for 4 p.m. on the closing date as opposed to the day after at noon. Yeah. Thinking that they're just going to get the keys early. But getting the keys early might mean that the seller has to have their money in hand before they're willing to give up the keys early.
Yeah, absolutely right.
The odds are pretty low that the seller's going to have their money in hand by 4 p.m. on the closing date. Yeah. It's just not. And then people are saying, can't you do it? Can't you do it? I've said, well, it's not totally up to me because your bank hasn't given me money and it's 1 p.m. But by the time I get the money at 3 and go and give it to the seller's lawyer, the seller still doesn't have the money, and they're probably not going to do anything to make extended efforts to provide you with the keys because you don't get them till tomorrow.
Yeah, right.
So operate on the timelines that you're supposed to. And the fact that you want to bring a contractor in because you have to replace the floors or you have to paint and you have to move, those are your problems, not the seller's problems. And that's just what you have to live with if this is how you want to do it.
So, yeah, it's funny. We actually have a clause in our contracts that's about time, and that it's of the essence. And I always basically break it down for all of our clients that there's no ish. So if it says 12:05, that's it. 12:06 is too late. Right?
Totally. Yeah.
There's no 12:04 is too early. It's 12:05. That's it. Right.
And while sometimes somebody may acquiesce and allow for things to happen earlier or later, whichever the case, it's not an obligation, and you can't expect it, and you can't demand it.
Yep, absolutely. Right.
So while we can try to accommodate, it's just not guaranteed.
Yeah.
So that's a big thing that people have challenges with.
Yeah. Cool. So make sure that people slow down, read the contract very carefully, because it's a binding thing. Right? It's not something. Plus, we're not playing around. Like most places are at least $500,000 plus. I don't know about you, but I don't screw around. It's to get the cash, right?
Well, and especially like even the standard form conditions. A lot of people get hung up just on the terms that they're adding in. Read the standard form conditions, because you need to know about that stuff.
Yeah.
Like the risk transfers to you as a purchaser at 12:01 a.m. on the completion date. Yeah. Like, but I don't get possession for 3 days. Why do I have to insure the house? Because it's yours now.
Yeah, absolutely.
Or because the contract has risk transferring to you.
Yeah.
And so
technically you're a landlord for 3 days.
Basically.
Right.
Sort of, yeah.
Yeah.
It's not far off of that. So
have you ever had anything come up with that? Like, I know that's generally the way that it is transfers at 12:01, and there is sometimes a gap there. Mm-hmm. Like, have you ever had to deal with, someone's pipe burst during that 3 days? How does that look? How does that?
I have had, I remember one in particular where the seller, I acted for the seller. Mm-hmm. They were selling a townhouse, and they moved out and had a shower on the last day after they finished moving and that sort of thing. Yeah. Everything was fine. Buyers came in, I think 2 days later, next day, something like that. Water heater had burst, water all over the garage floor. Like, not a big, no damage from it.
Like it was on the garage.
Yeah, exactly. But the water heater had burst, and they were like, well, the water heater bursted. You have to replace it. We got here and it was like that. She's like, it was fine when I left. I don't know what to tell you. I had a shower. Like, it worked fine. Mm-hmm. This wasn't like this. It's the buyer's problem.
Yeah, absolutely.
I think she settled on like splitting it with them just by virtue of like, she was a decent person.
Yeah, just doing the right thing.
Yeah.
Yeah.
But if somebody's asking me for $5,000 to do the right thing, if it's not my obligation, I'm not sure that it is the right thing. Like
fair enough.
If they don't have insurance to deal with it, and I mean, insurance isn't going to help you anyways, because it's not like insurable damage. It's just you have to replace your water heater because it broke. Who has that sort of money just laying around to be overly generous with?
Yeah.
I mean, I guess it depends on a variety of factors in that sort of instance, and it would be a moment by moment decision.
Yeah, so. Absolutely right. One of the questions that we did have sent in, I don't know if this is your type of law. Mm-hmm. It's they asked, do you have a particular insight on rules governing a paying guest situation, one kitchen, and security deposit requirements and terminations? Like if they're sharing, I guess it's almost a roommate situation.
I was just going to say, yeah, it sounds more like a roommate situation. And generally speaking, to the best of my knowledge, so no, I'm not a tenancy specialist.
Yeah, there's a different type of law.
Yeah, I mean, you sort of end up knowing a little bit about things just by virtue of being involved in the industry. Mm-hmm. But generally speaking, roommates aren't governed by the Residential Tenancy Board, depending on some situations. Sometimes it could be, sometimes it may not be. Roommates may not be, or I don't think they always are. You would probably
they're not actually. Roommate situation is not covered. Any of the like if you share a kitchen, there's no protection. You can't go to the Airbnb.
Okay, that's what I thought.
Do not
so
exist.
Things like roommates, international students, like all those kinds of things aren't RTB or Residential Tenancy Act applicable. So whether I have any insight on rules, I don't think there specifically are rules other than like general sort of civil obligations. But I think you would just try to draft up a contract that meets each person's respective needs and that is fair to both parties as much as it can be. Or if you want to be a dickhead landlord, then I probably shouldn't say that. But if you want,
right. it's a family show.
If you want to be the type of landlord that is mildly reprehensible, then you may try to just make it beneficial only to you and not to your I don't want to use the term tenant, but housemate.
Yeah, don't worry about the PC, man. It's fine. We drop F-bombs on this show all the time.
But yeah, I think that ultimately probably need to speak to somebody. I don't think there are a lot of just straight up tenancy lawyers out there because most people that are in that situation are fighting over like hundreds, if not thousands. Like, we're not talking about huge amounts of money for the most part.
Yeah.
So
it's almost not really worth it to go and bring in the big guns over a $500 issue type of thing.
Yeah.
Right?
I mean, who wants to pay a lawyer several hundred or several $1,000s for their time to fight over $800?
Yeah, fair enough, right? Now this is interesting actually because it sort of bring up. Also, apologize to our listeners. We just had the air come on, so I don't know if it's going to pick it up or not. But just want to give you the heads up. It's funny we're just talking about.
Yeah, it is a little bit noisy in here sometimes. So
yeah, that's okay. We'll find out.
I didn't even talk about that.
No worries. So actually, one of the questions we had, I think it's a bit of a troll question, but it actually is a relatively reasonable question. A notary does transfer titles for less than a lawyer, and apparently you're not needed. Are they cheaper? What's the difference? Like, I mean, you both transfer titles, but like, why would you use one over the other?
So it's an interesting question that is often debated in the industry in BC. Generally speaking, in BC, notaries are a subset of the legal profession.
Okay.
That doesn't mean they're lesser. It's just a subset. And when I say subset, it means that they have certain limited scope in how much they're able to do. Mm-hmm. In BC, all lawyers are notaries. Not all notaries are lawyers, as obvious by that. But so everything that a notary can do, a lawyer can do. Mm-hmm. And not the other way around. Are they cheaper? Sometimes. Not always. And I know you and I have had this discussion before. I remember very clearly a situation where a notary and I were on co-paneling a sort of public legal education seminar about purchasing homes, and somebody asked the question about costs, and so we broke down our respective costs for doing it. And at the end of it, she was like $200 more than I was. Is that always going to be the case? I know some notaries are cheaper. I know some lawyers are cheaper.
Yeah.
I do kind of remember that probably the single lowest cost person that I ever sort of saw in the industry, aside from me when I first started, was a lawyer. He was just like way less than everybody else. I don't know why. I don't know how he survived or managed to make money at it, but or provide decent service, because that's a part of it, because there is a lot of administrative elements to this, and if you don't have people that you're paying to do the work, things can easily get left behind. So
I mean, it's sort of like there's certain real estate companies that I'm not allowed to mention my name because I'll get in trouble and then I'll have to hire a different lawyer. But yeah, they do it for a lot cheaper, and you kind of go like, how are you surviving this? I mean, it's just strange because I'm like, do the quick math on it, like you're going to need a lot of deals to eat. Yeah. Or otherwise, you really like Mr. Noodles, but one of the two kind of thing.
Which is fine too. So I did make a couple notes on this because you had sort of let me know that this might be asked. So, like I said, the cost isn't generally cheaper, but it's often, there's a pretty normal band that most of us operate within.
Yeah.
As far as I'm aware, I'm pretty middle of the road based on what people have told me. I get clients in here regularly that say like, "Oh, you should charge more." I'm like, "Well, you want me to up your bill? Because I can do that."
Like, no problem, right?
And I do know that there are people that are way more, and there are people that are less than we are.
Yeah.
And I know I'm not trying to be the cheapest, but given that I know several notaries that charge more than I do, that's the best way I can answer that.
Yeah, absolutely.
There are good and bad versions of all of the professions.
Mm-hmm.
There are lawyers that will probably provide some substandard service, and there are notaries who will also but also can provide excellent service and have really robust teams and good knowledge, and so it's a mix. There are differences in standards and expectations. Mm-hmm. I support that the notaries are in this profession. Like I don't.
Yeah, absolutely.
I'm not trying to say that we're better or worse. We're doing generally the same thing, and in 90% of transactions, it's going to be more or less the same.
Yeah.
I do find in my experience generally that there are times where things are arising where we, as lawyers, we may tend to think about something a little bit differently because we are always having to think about things a little bit differently.
Yeah.
Even though our stuff's mostly transactional, we always have to be problem solving.
Okay.
Whereas that may not be a part of it, so they may not see the same thing. A lot of them do, and it's great, and so it's fine, but it's not always going to happen.
Yeah.
But some lawyers might not do it too. So
yeah, absolutely. Now, because generally for me, when my clients will ask me, should I go to a lawyer or notary? Because I have, numbers for both type of thing. And it's sort of, here's everybody.
Yeah.
I don't know if this is correct or not, but I generally judge it based on how many moving parts it is. Like if there's if it's purchase and sale, or there's something weird going on or whatever, I sort of say, oh, maybe you want to get a lawyer just in case things go off the rails. Whereas if it's going to be what I deem pretty clean and tidy, vacant place, whatever, like this and tight.
We like those too.
Yeah.
We prefer not to have problems.
Yeah. But I can just sort of figure, like, if it's clean, then I'll just go. You can probably just go to the notary. You don't need it. I don't know if that's correct or not. I'm not a lawyer, as you might have noticed.
Especially because people don't want to pay us extra just because something's harder.
Yeah.
So that actually kind of ties into another point that I made, which is that the actual ability to act in some/many transactions is notably different. So notaries are not able to act in contentious legal matters.
Okay.
So in the deal I was talking about earlier, where we're talking about this hotel property and the dispute over whether that money is owing or not owing, I'm not 100% sure, because I'm not totally tied into what the notaries are allowed to do, because I'm not one. So I don't.
Yeah, of course.
I don't know where they set their standard of what is considered contentious or not.
Yeah.
But it would be, my starting point would be that a notary wouldn't really be able to negotiate on behalf of their client for that matter. They would have to say, sorry, you're going to have to talk to a lawyer to get advice on whether or not this is something you can address.
Yeah.
Because it involves contentious interpretation of the contract. So there are times where I get calls on the completion date. People are like, my notary told me to call you because we're dealing with this issue.
Yeah.
I don't know about you, but I kind of would want to be in the position where I've already got the relationship with somebody, instead of somebody that's going to go, sorry, man, I've got 8 deals closing today. I don't have time to talk to you. Like, if you had called me 2 months ago and I was helping you from the beginning, we'd sort it out now. But you
got to catch up and know what's going on where you are, right?
So, so that is a bit of a challenge. I'm not saying that people shouldn't go to notaries, because again, most of the time everything's fine, but that would be one of the things to consider.
Yeah.
And like, ultimately, just find the person that you want to work with, that you like the way they operate and where you're content with the fee structure. There is a range. It's not generally a super wide range, but it's a few $100 here and there can make a difference.
Absolutely.
And that can sort of go a few different ways. I mean, we have a pretty good system here where we have a good staffing level. There's somebody that's dealing with you at the beginning to source information. There's somebody that's handling your file. There's somebody that's helping complete things. We have a dedicated in-house bookkeeper.
Yeah.
So there are lots of people to help make sure that things go really smoothly, and that costs money.
Yeah.
Right. A larger notary office is going to have a similar structure. If you get a little one-man show and they can do the whole thing, great. That's fine too. But when it starts to, they get busy and things start to pile up and you're going, can I get a copy of my final title? I never received that. Is everything okay? Like,
yeah.
And they're like, oh, sorry, I'm just behind, so that's more of what you're paying for than whether it's a lawyer or a notary.
Okay.
So,
yeah, which actually is a good segue. You're talking about the papers and all that. With all the above, the lawyers and notaries, what happens at the conveyancing? Like, we're aware that we sign the contract and we send it to lawyer, notary, and then it gets done. I don't know what happens.
Then your next step is to give keys away.
Yeah. So like, what happens after those arrive?
I mean, not a lot.
Yeah. No. we just toss it in. It's fine.
I don't know. I say, sure, I can help. And then I'm writing checks. I don't know.
Yeah.
No, basically there is quite a bit to it. So I can go into a lot of detail or give a kind of high level overview.
Yeah, probably go with the high level because I don't think anyone's using this show to become a lawyer.
The short version is that we gather a lot of information. So we get your contract information. So your contract, the realtor's commission information, the associated documents like copies of titles and strata documents and disclosure statements and stuff. Sometimes come in, not always. But anyways, we gather a bunch of information from the realtor side. We gather a bunch of information from the lending side because most people have mortgages. So there are a notable number of documentation and documents that come in mortgage related. Some are more complicated than others, and some require a lot more effort on our part. And generally, yes, we do charge more for those because it's more work.
Fair enough.
I sometimes think of a plumber who has come to change your kitchen tap, and they go, "Oh yeah, that should be probably this much money," and then they get under there and they go, "Oh no."
Yeah, there's a whole bunch of things going on.
Well, now I have to get this part and I have to do that thing, and I have to. So it's going to cost you like quite a bit more than what you thought. Yeah. Well, there are some lenders that are like that for us. So
okay.
But in any event, we get your lender information, we get your contract information. We have to gather a bunch of client information, which has expanded notably over the years to now we're heavily involved with source of funds information, for example. So the anti-money laundering side of things. So we have to ask about how you got the $200,000 that you're giving to me to complete your purchase.
Yeah.
And if you are a student, it's a hard question to answer, and I'm going to have to really dig into the source of funds and maybe even get banking records and tracking. And if it's easy to explain or your parents gave it to you, then we might have to get information from how they got the money. You know, because we actually do have to make reasonable inquiry as to how these things were happening. And if we can't verify source of funds, or if it, the questions are too conspicuous, then I will decline to act. I'll say, I can't act for you.
So now does that go through, like we have to get the fin track filled out? Do you receive the fin track, or do you kind of do your own?
We have to do our own thing.
Okay.
Which we have to sort of make reasonable inquiry as to where it is. So for example, a heart surgeon of 30 years is giving me $200,000 towards
it's got makes sense.
Or a student who has literally never had a job is giving me $1 million for a cash purchase. We may have some questions.
Do they have the little MERS? Because I can tell you where that comes from, probably.
I don't have any comments on that. So in any event, we have to gather information about people, full legal names, occupation, social insurance numbers, dates of birth, etc., because a lot of that goes into property transfer tax and other information. We have to talk about how people want to have their title structured. We have to review the contracts for those aforementioned terms that may create challenges for us. We prepare a bunch of documentation that goes out to the seller side to deal with the actual transfer of title side of things and some CRA, GST related documentation, non-resident sellers, property transfer tax information, and the actual statement of adjustments, which is the only part everybody cares about, which is the breakdown of the money in and out. So what the seller is being credited with and debited for, because we have to deal with adjusting for property taxes and strata fees. And so there's a bunch of investigations that we have to do to gather those types of information. And then we break it all down into two documents, a buyer statement of adjustments and a seller statement of adjustments. And those are then what are used to actually deal with the actual division of funds. Ultimately, we get money from the lender after you've signed all your mortgage package of documents with us. The seller signed their transfer related documents. You've given us your down payment and closing costs. We collect the money from the lender on the closing date. We do some title verification and whatnot to make sure that the seller hasn't added mortgages to title and that sort of thing. We file the transfer. We pay out the seller's lawyer accordingly. There are steps involved in here, but we pay out the seller's lawyer accordingly, and they're put on an undertaking to clear any mortgages from title if the seller has any, or other related things, landowner, land tax deferments, or still see some MSP reg charges from the government, crown liens and stuff like that. Yeah, before we had to start paying for it all.
That's a different show.
Yeah.
For all this though, it sounds like there's a lot going on. What's a reasonable time for a closing? Because I know that's once in a while we'll have somebody who wants to have their closing date like a week after, and it seems like really rushed.
It is.
Yeah, what would you say is the shortest amount of time that would be reasonable? 2 weeks, 3 weeks for closing?
2 weeks is it can be done faster. Don't get me wrong when I say that shortest reasonable amount of time. 2 weeks is relative ideal as a minimum.
Yeah.
Because that gives enough time for a lender to issue instructions. A lender's not issuing mortgage instructions and finalizing your mortgage until you have a firm contract.
Yeah, absolutely.
They're not going to go to all the effort to prepare that documentation if you don't have your subjects removed. So your subject removal timeline being Friday at 5 p.m. and expecting a mortgage to get to me on Monday at 11 a.m., it's not happening.
Yeah, absolutely.
So there's the mortgage side of things, subject removal timeline. And so you kind of want to have a couple of clear weeks in there, because that gives enough time for us to do all that stuff I was just talking about, which takes time. Strata documents, if you have less than a clear week to order your strata documents, clear week isn't quite technically true, but we'll just call it that for the moment. If you have less than a clear week for us to order strata documents, you're paying rush fees. Yeah. And you're paying rush fees. I'm not paying rush fees. Yeah. You're the buyer in this instance, of course.
And the rush fees that strata companies they're getting brutal right now. $700 for a Form B, one paper.
Yeah. And for the most part, it's information that should be pretty easily accessible to that strata management company.
Oh, absolutely.
But at the same time, they suddenly have to drop everything to do this one on a rush. Yep. And actually, a strata management company isn't obligated to provide rush service.
No,
they're not. The Strata Property Act defines that a Form B, an information certificate, has to be made available within 1 week of the order being placed. Now, within 1 week has Interpretation Act definition timelines involved in it. What does within 1 week mean? And it's, next business day, blah, blah, blah. So if you order it on a Monday, it would be the following Tuesday that it has to be available. And some of these strata companies are your document will be available on Tuesday at 4 p.m.
Yeah.
Okay, if it's ready on Friday, can you send it to me then? No.
Yeah. Okay, I did that all the time.
And there is no requirement under the Strata Property Act to provide rush service as an option.
Yeah.
There goes the AC again. Right. But yeah, so those are things that can impact the timing, and that people don't want to add rush fees necessarily. And just because you've told me that subjects are off, if I don't have your deal in hand, I'm not ordering strata documents and stuff until I get your stuff, because I don't want to spend money on things that I might not actually happen. Somebody's like, I found a notary down the street for $50 less. I'm moving my file, and I've already done a bunch of stuff.
Yeah, exactly. And then off you go, right?
Everything's got to come in.
Yeah.
So that's one reason where 2 weeks is pretty usually okay, as long as everybody else is doing their part.
Yeah.
In terms of the mortgage coming in, the Realty office delivering documents. We've had some Realty offices, little kind of places that don't really have proper administration, where they don't send us anything till 3 days before completion. And you're like, okay, well, do you not want to get paid? And do you not want the deal to go smoothly? Because that's helpful too.
Yeah.
So that can be challenging at times. So there's a lot of stuff that's outside of our hands. And if I have to start chasing that stuff down, that's more work that I'm doing. And we go back to the plumber.
Yeah, right? Exactly. And then here it just keeps on stacking up.
And it might not be your fault. You're my client. It might not be your fault. But who am I supposed to charge? I can't charge that realty company. No. I'm having to spend a bunch more time. That's time I can't be spending doing other work. Mm-hmm. So at some point, we don't generally do it. But if it gets particularly complicated and time consuming, we might have to charge you.
Yeah. Fair enough.
So more time is better, basically.
Yeah. So as long as you can possibly do, but minimum of 2 weeks is probably fairly safe to get things done in a reasonable manner without having your hair on fire, right?
That being said, have I done things in a day? Yeah.
Yeah, absolutely.
I used to have hair, but it burnt off.
Now, there's a thing called title insurance. You touched on titles. how important is that? A lot of people don't worry about it. I mean, and its function obviously is for nefarious reasons coming up, scams and whatnot. And I do imagine scams are picking up.
It's not only for scams.
Okay.
There's a lot of stuff totally unrelated to scams that it covers.
Okay.
It does generally cover like the sort of main things that are most commonly protected by title insurance is fraud and forgery.
Yeah.
When I say most commonly, that doesn't mean commonly.
Yeah.
Right? Like there is a big difference between those two terms.
Yeah. You're getting real lawyer now.
Well, but commonly would suggest that it happens all the time, and it doesn't happen all the time, and especially not in BC because we have a pretty good land title system.
Yeah.
We get title insurance on every deal.
Okay.
I don't want to work for you if you don't want title insurance generally, because I don't want you coming back to me saying, well, how are you going to help with this?
Mm-hmm.
I'm like, well, if you had got your title insurance policy, you'd be fine. Now, a lot of times you don't have a choice. Generally speaking, if you have a lender, title insurance is effectively a requirement. And the reasoning for that is that if you have a mortgage, we are obligated to give an opinion on title,
mm-hmm.
which could be a very costly thing to do if we were going to do it fully.
Yeah.
Where it would mean pulling charges of all the information on title, reviewing copies of them all, saying what all the covenants and easements, and you go down to a place on the water in New West and it has a 26-page title search of covenants and easements and air rights and all that stuff. I'm charging you probably $10,000 to
get to go through all that. Yeah.
Or you can get a title insurance policy for $175.
So seems like a pretty easier way to do that, right?
Basically if you have a mortgage, and there's a lot of lending where one of the requirements is to provide a title insurance policy.
Yeah.
So it's kind of it eliminates the decision. There's also homeowner and lender title insurance policies. Generally speaking, we add the homeowner on because it's like $25.
Yep.
It can be a factor when it's over $1 million and the price discrepancy creates a more expensive thing. But I don't know about you, but if I was going to have fraud and forgery protection, title related protection, survey related defect protection, all that sort of stuff, that's what it's for a homeowner. I've had clients. I had a client who was buying a place in Whistler. Whistler's notorious for ad hoc renovations, one might say, where a lot of stuff is done without permits. One of the things that title insurance covers against is work done without permits.
Mm-hmm.
If you're buying a place and you don't know that work was done without permits, so it's not been disclosed to you in the contract, it's not in the property disclosure statement, there's no reason that you would know that the basement suite they put in was done without permits. Mm-hmm. And then you go to do something and you call the city in to get permits for something and they're like, what is all this?
Yeah.
We haven't given any permits for any of this stuff. You have to bring it all up to code. You have to do that sort of thing. True story that happened to clients of mine. They then have to, those buyers then have to deal with the city and bring all that stuff up to code or take it out or whatever the case. Title insurance protects you against the financial repercussions of that.
Okay.
I had clients who bought a property in Squamish and it had a basement. It had 2 basement suites actually. And literally the day after they bought it, the district was knocking on their door saying, we understand there's unauthorized accommodations and work done without permits in here.
Yeah.
And they called me in a panic and was like, remember that $400 discussion we had about your title insurance policy because their property was more expensive?
Yeah.
And you got it? Call them. And, $24,000-ish later, 40,000, something like that. Everything was done. Title insurance covered it all.
It's kind of nice to have insurance when you need it and a real pain when you don't.
The client purchasing in Whistler, that home where she said, no, we're going to be doing a bunch of work anyways, so we're going to get surveys and stuff. So we're just going to get a survey, which survey often costs more than title insurance, by the way.
Yeah.
They wanted to get a survey instead because they were going to need one for the stuff they were doing. They find out halfway through their process that the municipality is like, nope, none of this stuff is allowed. You got to fix it all. And she had about $75,000 that would have been covered if she had got a title insurance policy. Didn't, and so wasn't covered for any of it.
Mm-hmm.
And she even said, I wish I had listened to you.
Yeah.
Well, I do too.
Now, if they discover defects like this, once you purchase, material latent defects, ones that can't be easily discovered, what's the best move for somebody in basically this situation? Yeah. What do you do, whether you have insurance or not? Where do you go from here, basically? Is
So material latent defects are a pretty complicated area of law.
Yeah.
And
for people who don't know what material latent defect is, it's one not easily discoverable.
Well, that's what makes it latent.
Yeah.
What makes it material is that a defect that's not easily discoverable upon reasonable inspection. Mm-hmm. And what makes it material is that it also makes the property uninhabitable or unsuitable for the purpose it was designed.
Yeah.
So it makes the house that you purchased unlivable.
Yeah.
So things like a crack in the foundation may or may not be considered a material latent. It may be latent, but it may not be material because it can be fixed.
Yeah.
Or it may not make the property uninhabitable unless it's, if it's making mold and that sort of thing.
Yeah, of course.
So that's why it's a high bar and it's a complicated area. So what do you do in those situations? Because you're going to figure them out afterwards.
Of course.
You're calling a civil litigator.
Okay.
Generally one that works specifically in real estate.
Now, you talked about earlier with titles and different things on the titles. There's a couple of different ways to be a tenant, joint tenancy and in common.
Mm-hmm.
Can you explain first what the difference is between the two, and then why you would choose one over the other, or vice versa? Why is there more than one?
It's to do with fundamental structure of ownership.
Yeah.
And joint tenants is really exactly what it sounds like. Why they use the term tenants, it gets into a long joint owners.
Yeah.
It means that you own it together as a unit, whether it's you and your spouse, you and your family, your parents and your siblings, and everybody owns this cabin in the woods together as joint tenants, or the whole family lives together in one house and you all own it together as joint tenants, whatever the case.
Yeah.
So that's where you own it together as a unit. So I like to do it like when I'm describing it for clients, I'll draw bubbles.
Yep.
And these are the bubbles of ownership. If you're joint tenants, you're all in one bubble.
Mm-hmm.
If you remove a person from that bubble, somebody's passed away or whatever the case, everybody else is still in the bubble. They still own the property.
Yeah.
If you have spouses, they own their house together, one of them passes away, the surviving spouse still in the bubble.
Yeah.
They still own their property and are the sole owners of that property, because the deceased has intended through joint ownership to create a right of survivorship, which means that person still resides in it. The difference is tenants in common is that you make your title ownership subject to multiple bubbles.
Okay.
So you and I are buying an investment property together. You're putting in 70%, I'm putting in 30%, and we're going to split all of our costs 70-30.
Yeah.
We have a contract. Everything's great. How we're co-owning the property. Your share of title is going to be 7/10 or 70/100, depending. It's all done in fractions, not percentages, but so your share is going to be 70%. My share is going to be 30%. And then if I pass away, my share goes to my estate, whoever I leave it to.
Okay.
That may be my spouse. Mm-hmm. Even if she's not on title with me, she doesn't have a right of survivorship. It's who I've left it to.
Okay.
Sorry, phone's buzzing here. So it's who I've left it to, and that's who will gain the benefit from it. But going through a process in order to obtain it. What happens when somebody dies, the whole probate process and whatnot, which we don't have to dive into too much detail, but short version is it's costly and takes time.
Okay.
As opposed to joint tenancy, which is very easy. So if I really intend for my spouse to be the sole beneficiary of my share of it, and she's going to be part of our bargain between you and I should own it with her as a joint tenant.
So you're both in the bowl.
Yeah. But if I don't, and in many cases people don't, my share will pass to her through the probate process. Okay. Or if I've left everything to the SPCA,
Yeah.
You're going to become a co-owner with the SPCA. And then that deals with the whole co-ownership agreements and that sort of things as to what happens and whatever the case. So, but that's fundamentally the difference is the bubbles of ownership and what happens if people pass away. An important distinction to make, though, is that what you see on title for the fractional interest or the percentage ownership is not definitive as to the person's beneficial interest, meaning the actual amount that they own.
Okay.
It may be different. It's an indication and a strong one, but it's not the only.
Okay.
So really important to note that just because you see 70-30 on title, it doesn't necessarily mean that it's 70-30, because we may have gone into our agreement going 70-30, but then you were a deadbeat and didn't make any of the payments, and I've been paying the whole mortgage for a bunch of time and in turn have developed a bunch of extra equity. And so now I effectively own 50% of the property. That can be a factor as well.
Okay.
Because we're not changing title every time something happens.
Yeah. And so now for people like investing in a property, properties are quite expensive now. So people usually do it with more than one.
Mm-hmm.
Which would you suggest would be the better option for that function? Like probably the joint tenancy or tenancy in common? Generally
not joint tenancy if they're doing it as business partners.
Okay.
I would actually never recommend joint tenancy when doing it as business partners, because unless the intention is to create a right of survivorship and that you are supposed to benefit in my 30% if I pass away, which I like you, but I don't like you that much. The reality is that it's the wrong.
Yeah.
You're creating something that you're not intending to create.
Yeah. So if you're investing with a business partner or partners, then probably tenancy in common is the best way to go about that for. Yeah.
If my brother and I are buying a cabin in the woods together as we have a place to go recreate with our families and whatnot, we should do tenants in common because we want our respective shares to go to our families as opposed to each other.
Okay.
Because otherwise I'm donating a bunch of money to somebody that I'm not intending to.
Yeah, that absolutely makes sense. We had one question that came in for the properties and property managers and DIY landlords. What are the best legal practices for handling security deposits, evictions, and tenant disputes? Like, what's the best way to put yourself in the best position should something go wrong?
I feel like that's a really easy one.
Yeah.
Follow the rules.
Yeah. Like a TA.
Just if you do everything right, yes, you can still be in a position where you have to fight because our whole legal system is based on people being able to fight with people, whether or not they are right or wrong.
Yeah.
But if you've done everything right, you're in a much better position to come out on top than if you have cut corners, forgotten to do things, done things incorrectly, whatever the case. That really hurts your position, especially as a landlord, because I think most of us are aware that particularly in dealing with the RTB, our system does tend to favor the people who are lower on the power scale, which is usually the tenant.
Yeah.
In some ways, at least. I mean, the pendulum seems to have swung fairly far just by virtue of that, and with the challenges in evicting and that sort of thing. But ultimately, the tenant is the one who doesn't own the property, and so would, generally speaking, have the RTB side with them if there's a dispute over whether somebody did something right or wrong.
Yeah. Now, and you also touched in earlier, we were talking about tenancy in common and joint tenancy and that. So people generally are investing together. What are some good clauses obviously a high overview, we don't want to get right, it'd take a long time to get all the way through it. But what are some decent clauses to put in there to sort of help everyone? Because, when things are going well, they're awesome. But, say somebody has a kid and wants to sell and the other guy doesn't. What's a good clause? A lot of people talk about like the shotgun clause. I don't know what the actual legal term is for it. But it seems to favor whoever's got more money, right? Is there any better ways or what would be a good way to do that to make sure that everyone can have a easy exit or a reasonable one at least?
Yeah. So I mean, number one is to have an agreement.
Yep.
Because that's the biggest problem, is that many people don't. Mm-hmm. And that creates its own set of problems. Make sure that you're being careful about who you enter agreements with, mm-hmm. because what might seem like a good idea when you're drinking pints at the bar on Friday night and you text your realtor buddy and make an offer and then you win it and you're sober on Monday and go, shit.
Know it.
So, there's that. So there's a lot of external factors to consider when, as to who you're dealing with. And a lot of times people sort of say, we don't need an agreement. We're fine. We get along great. Everything's good until it's not.
Yeah, absolutely.
And that's why we do these things, because then you have something to define clarity of terms.
Yeah.
What's happening if things don't go the way you're expecting? Yeah. Or how do things happen when things you haven't considered come up? Mm-hmm. And, we can't consider everything. We're not going to remember to put in every single thing that ever got considered, because most people don't want $20,000 agreements that are 100 pages. Yeah. They want a 5 to 10 pager that governs most situations of, general applicability, and that costs somewhere between, $1,000 to $2,000 or something like that.
Yeah.
Right. So that's one thing, is make sure you have an agreement and that it suits your needs. Mm-hmm. Now, what sort of things to put in it? I mean, you have your sort of definitions of who is involved and who owns what, and mm-hmm. what people's respective shares are and whatnot, and how people are going to contribute to the property.
Yeah.
And my best advice on that is to pick a number and stick with it.
Yeah.
If you're going to do the 70-30 thing, you pay for 70%, I pay for 30, all costs.
Yeah. Just keep it the way it is, right?
Then we never have to fight about it down the road, because you always paid for 70, I always paid for 30. I can never claim that I have more. You can never claim that you have more, because it's always been done properly all the time.
That makes sense.
Because making adjustments down the road and forgetting about the fridge that you paid $1,000 for and we were going to get it from me later, that's a problem. So that's one thing. And so how you're defining the contributions. Another important element is the right of survivorship, the succession elements of things. People get hit by buses, people get cancer, people get sick, people slip and hit their heads on concrete and become incompetent.
Yeah.
How are you going to deal with that?
So sort of, think about the worst case scenarios. Generally won't come up, but it's better to have a plan just in case.
What happens if?
Yeah.
And you have to be reasonable in those, right? You can go, what happens if aliens attack? And you go, okay, well, what kind of aliens? Do they want to preserve our properties or do they want to destroy them?
Yeah, fair enough, right?
So let's not worry about that, and let's focus on more likely scenarios.
Yeah.
So succession clauses are important. Termination clauses, and that's what you're referencing in particular, is what happens when one person wants out.
Yeah.
You can't generally force somebody not to sell a property. Mm-hmm. Now, being able to sell your interest in a property, we have an agreement for 70-30, and I'm like, hey, man, I'm having a surprise child or something, and I need my 30% back, so I need out.
Yeah.
And you're like, okay, well, I don't have the $300,000 or whatever to pay you out, so I can't do that. And I'm like, well, then we have to sell.
Yeah.
And you go, well, I want to sell. I want to keep it. Well, then we have to find somebody to buy my share, or we have to sell because I need my money and I have the right to dispose of my interest in that property, which may mean disposing of your interest in that property. And sometimes it involves going to court and getting an order for sale because you don't want to do it. And
and then
I'm a lawyer, so I win. But people can go to court and get an order to sell the property because that's time to do that.
Yeah, absolutely.
The idea behind shotgun clauses and those sort of termination clauses of there's sort of right of first refusal elements to these things. A shotgun clause favors the person with more money because they're the only person who has the wherewithal to finalize, to be able to do it. If the other person can't do it, then they don't, then they're not able to bet. Like that's
fair enough. Right?
Money wins.
Yeah,
but that's why people are doing this, to make more money, right? Like, so you do this and you hope that it works out, but that agreement has to be worded in such a way as to be fair, so that at least if somebody is doing something where you're getting bought out, that you're getting bought out fairly. Yeah. And if it's fair, then it doesn't, you're not losing.
Yeah, fair enough, right?
Sure, the other person is the one that's able to do it because they're able to buy you out or force the sale or whatever the case. But it's because you don't have the capacity to not do it, or to fight them on it. Like, somebody has more resources. That's
just sort of the name of the game, right?
And it's not taking advantage. It's not unfair in the sense that it's just that somebody can do more than another person. I mean, I drive a Honda. There are lots of people that drive Maseratis and Rivians and stuff. I'd love to, but I don't.
Yeah, fair enough.
Because why is it fair that they get to? Because they have more money. They've earned it, or maybe they haven't earned it, but they have it.
They have it. The main gist.
So that's it is what it is. But termination clauses are really important because then how things will happen and what can happen. What I need to sell, and you say, well, okay, I may not be able to buy you up, but I'm going to see if my brother wants to buy into this.
Yeah, buy your share kind of thing.
Yeah.
I got you.
And so that can be done. And if you can't find somebody that can buy my share, then the clause really should be that, well, then the property is getting sold. Yeah. And how much is it getting sold for? Then you can you have clauses in there about, like, you'll get multiple, you each get a realtor and average the two, or if you don't decide on a realtor together, that sort of thing.
Yeah, just get like an appraiser, whatever, maybe. Yeah. Exactly. I got you. And then now you had been talking before, we had gone to some sort of breakfast thing, and you'd said that there's been some changes that are happening from when a parent is trying to pass property down to the children or something of that nature. There's some changes. Do you want to touch on that?
Primarily regarding capital gains.
Okay.
The biggest shift lately, and that was June 21st of this year, I think, was when that really came down, was that there was a change in the capital gains rules about the amounts of money that are subject to capital gains and what percentages they're subject to, and that sort of thing. I kind of forget the numbers a little bit offhand because I'm not an accountant, so I don't have to worry about it specifically. But I think it's over 250,000. The gain, the percentage on gain goes up to 67% instead of 50%.
Okay.
I don't know if people know how capital gains works, but generally speaking, if you have a capital property, so one that's not a income producing property, in which case it would just be, or not an income producing property, but it's a capital asset as opposed to I forget what the term is, but something that you would just pay full tax on because it's sold sort of in the course of business. If you're in the business of selling properties, let's say you're in the process of building and selling, and so you make $1 million profit on the sale of that property, you're paying tax on $1 million.
Yeah.
If I buy a property for $200,000 in 1992 and I sell it in 2024 for $1.2 million and I made $1 million because it's been rented for however long, or then I'm paying tax on 50% of the gain.
Okay.
Or I was until June 21st. Now I'm paying 50%, I think is how, forgive me if this is wrong, but I think you're paying 50% on the first 250,000 and 67% on the amount over 250.
I gotcha.
So that's the one of the big changes. And so when it came to like parents transferring properties to their kids and whatnot, a lot of times, especially if it was like a parent's investment property or rental property, they, even if they're giving the property to their children, they still have to pay tax on it because it's a deemed disposition where they could have sold it and therefore paid the gain on it. Okay. So they don't get to not pay the gain because they sold it to somebody or gave it to somebody for less.
Yeah, I gotcha.
Less or nothing.
Yeah.
So that's a very important conversation to have with your accountant, though.
Okay. Yeah, definitely that. So basically, we've got through all of our questions and that there. If someone's trying to get a hold of you for more questions or to convey a property, how do they find you?
Best way is through the website generally, lebeaulaw.ca,
Okay.
LeBeaulaw.ca. You can reach me directly, Michael at lebeaulaw.ca, or info at lebeaulaw.ca goes to me and other people to have a better chance of getting responded to, because I get a lot of emails. But happy to help, or you can always call us 604-544-4535.
Perfect. Yeah, and we'll have that all in the description below. So if you've been listening this far, thank you very much for joining us. This has been Bamboo, Vancouver's property management and investment podcast.
Cheers. Thanks for having me.